So a little bit about me before I get started. I'm an attorney in a Holland & Hart's healthcare group. Unlike a lot of the attorneys in the group, I tend to focus more on representing payers than providers, although I do have represented providers in a number of contexts, including negotiating managed care contracts all over the country. So with that, I'm just going to get started here and move to the first slide. So just general background. We all know this, that the provider networks, managed care contracting is an area of rapid change. Commercial payers are experiencing the health insurance exchange market, and that's leading to changes all over the country. The Affordable Care Act is actually behind most of these changes. Medicare experiments with accountable care organizations, other value-based payment models, all adding up to having a new emphasis in narrow networks, risk and gain sharing, utilization management, all the managed care, hallmarks of managed care that we've seen in the past. There's been a trend, reemergence of provider-owned plans, or providers interested in forming joint venture plans with existing payers. What is different now, most of the authorities and experts in the field seem to say that what has changed is the rise of big data, the ability to mine data on a real-time basis, electronic health records, and that provides better real-time tools to manage care with current information rather than constantly referring to dated and old information. Generally speaking, we're looking for better value, emphasis on outcomes and quantifiable quality metrics over fee-for-service. I've heard an estimate that up to 15% of annual healthcare spending will be in some form of pay-for-performance model. So that's the background here. I'm going to move to the next slide, which is just introducing the topic of managed care contracting, and this is going to be a pretty nuts and bolts and fairly an ABC's kind of approach to some of the basics of managed care contracting, the high points that can be the most painful for the parties to the contract. One of the first issues is just who is the party to the contract. Frequently, both parties, the payers and the providers, will want to contract on behalf of affiliates. This can be problematic for both sides because it becomes unclear who is entitled to benefit from the contract, and that can lead to disputes and uncertainty. The recommendation is make sure that your contracts define the group of people, of affiliates who can benefit from the contract, and then addressing the issues such as if there's multiple unnamed or named or unnamed affiliates who are able to benefit from the contract. You'll still want to address who has the rights to enforce the contract, and the issue of what about breaches of the contract by affiliates who are not parties to the contract. So they can benefit and they're supposed to comply, but then they don't. The way we typically address that is we want the signatories to the contract to be responsible for breaches of affiliates and any indemnification obligations that are triggered by actions of the affiliates. I'm going to pause here just to mention something I should have mentioned at the beginning of this presentation, which is that due to the nature of the webinar format, we have all callers muted. I would encourage folks to send questions, and if I can, I'll answer them during the presentation, or if not, I will provide answers via follow-up email that will provide the questions and answers. So if you have them, please use the WebEx tools to submit Q&A, and we'll try and keep track of that during the presentation. So on to the next slide here. Just a brief note here that there is a trend towards narrow networks, limiting participation in networks. Just to mention that some states, Idaho, Utah, have any willing provider laws that need to be addressed in any kind of contracting arrangement that is intended to only group to include one set of providers. As a practical matter, as I note in the second bullet point here, if terms of participation require clinical and financial integration or risk and gain share, you're typically not going to have a problem with the providers who are outside of that integration model trying to join the network. But it could be an issue. It's just something to mention and bear in mind when planning. Next slide relates to contracting around risk-sharing provisions. Just some of the issues that need to be addressed in a contract to avoid uncertainty, disputes, misaligned expectations. The first thing is defining the budget or baseline that will be used. Second thing is defining the costs and how they're calculated. Those seem pretty basic, but often are addressed in a way that's somewhat vague in the contracts I've seen. Next point is addressing amendments to fee schedules or other mechanisms used to calculate the costs. Obviously, when you're setting these things up, it's critical that there be agreement on how these costs are calculated and agreement on how they're amended. So you want to just be careful that amendment provisions are clear about amendments to those schedules and differentiate them from other amendments that maybe are unilateral by one side or the other, such as amendments to comply with changes in law. Other basic issues that just need to be addressed are the reconciliation and timing of payments, so that you know when payments will be settled and how they'll be how budgets will be reconciled against actual results. Final note on this slide is the issue of state insurance limitations. Each state will have different rules, whether published or unpublished, regarding the amount of financial risk that a provider group can take or a provider network can take on before it's moving into territory of becoming an unauthorized insurer. Okay, I'm moving on to the next slide here, which is contracting that involves quality metrics. Very many of the same issues as I just mentioned with risk share arrangements. You want to define the quality metrics with certainty, address the issue of amendments to the metrics, establish the goals that will yield any kind of shared savings, and the contract should address what kind of collaboration, how the parties will collaborate, data sharing, et cetera. More points about contracting with quality changes. When quality will be measured based on outcomes for a population, then critical for the contract to address changes in the population. What happens when patients come in and out of the network over the year? Which ones count and which ones don't count in the measure of quality outcomes? The other point is changes to the provider group. If you have providers that go in and out, which providers' metrics or results are measured, determining whether you've met quality targets. The other point, last point, is that typically the formula for calculating whether you've achieved the target should have some buffer to account for just random variations, such as a plus or minus 1% of the target would be considered meeting the target. That's a business and negotiation point, but it's commonly included in these types of contracts. Moving on, again, nuts and bolts stuff. Indemnity, typically you're going to be required to have an indemnity provision on one side of the contract, or both sides will want it to be indemnified. There can be challenges, however, with indemnity. For providers, they need to ensure that their liability insurance will cover the indemnity obligations. And an interesting point of Idaho law, which is where I practice, is that the law requires that indemnity provisions be mutual and of equal scope. So if a provider wants indemnity from a payer for something, the provider must provide that same indemnity and vice versa. I'm just going to continue moving on here. And then we get into the topic of amendments to contracts. The issue of amending the contracts is actually one of the trickiest issues, I think, in managed care contracting, and one of the most difficult to handle. Your first point is unilateral amendments are fairly common in these contracts, where one party or the other can amend the contract by providing a certain number of days notice. Those who, often it's the payer, but it could go the other way. And if the other party doesn't want to accept the amendments, their choice is to give notice and then terminate the agreement. Usually that's not the desired outcome from these, so there's a notice and comment or other sort of dispute resolution provision included in the amendment process to avoid having to terminate the entire agreement if one of the parties doesn't accept a unilateral amendment. So that's the unilateral amendment issue. It's fairly common. It can raise some difficulties for both parties. The other issues with amendments are the extrinsic documents. More and more often, especially as these agreements become more and more complex, there's references to outside policies, procedures, fee schedules, and other things that may or may not actually be included in the body of the contract. The contracting parties here should probably ensure that the amendments to those documents are included in the amendment provisions, or if they're not, be clear about what can and cannot go into those documents so that critical elements of the arrangement are not in extrinsic documents that can be amended at one or the other party's will without notice or consent. Second point on this slide returns to the unilateral amendment issue. The one way that these provisions sometimes get negotiated is that the unilateral amendments can be limited to amendments required by law or amendments required by one party or the other's accreditation. On the slide, I mentioned the payer's accreditation. That's accreditation. That's the new issue, as you know, all commercial payers all have to be accredited, and that's requiring them to include accreditation requirements in their contracts and potentially have to amend contracts to retain their accreditation. The final point here is that state law in some cases may limit the enforceability of a unilateral amendment provision. I wouldn't recommend that anyone rely on this. This is often in eastern states with a little bit older law. There is some precedent that contracts cannot be amended unilaterally. My view of that is that in practice it's common, and the direction of the law is that they probably are enforceable. But it's just a point that I've seen mentioned by others, so I mention it here. we've addressed amendments, so I'm moving on to termination. Just addressing the various issues that come up when in a termination provision for a managed care contract. A first point that is pretty important and often not very closely addressed in the agreement is the differences between terminating a single provider and terminating the entire contract. As an example, a failure of a provider, a single provider, to be licensed may be grounds to terminate that provider from the network, but probably would not be a basis upon which either party would want to terminate the entire network. As another example, if there's a commitment by the payer to deliver certain population size to the contracting network, and that commitment is not met, then the provider may wish to exercise the right to terminate the entire contract. To two very different types of termination events, and they really should be handled separately. So that it's clear which type of termination is being discussed. Then the final point regarding termination, I've moved on to the next slide, is both parties really should ensure that any notice provision in the contract it specifies methods of notice that will actually result in notice. It's common to have email or other types of notice authorized. When it comes to things like termination, the parties may wish to require a more formal form of notice, such as actual paper notice delivered by return receipt or a signature required delivery, just so that there's clear communication that the contract has been terminated. Still on the topic of termination, there's then the issues of, well, what happens when the contract is terminated? Typically, the contract will continue for some period following the termination, so that patients who are receiving treatment will continue to receive treatment at the contracted rates for a period of time. This, if it's not addressed clearly, can be a fairly indefinite and loose period of time, and the parties' duties to transition patients to providers that are in-network may be fairly nebulous. So the recommendation is that the contract should probably specify a maximum length for the period and address duties to transition patients. That brings me to the last slide on termination. I thought we were done with termination. And this last slide addresses the issues of terminating the financial impact, the financial considerations of terminating the contract. If you have a capitation, risk share, value-based arrangement, the termination provisions of the contract should address timing of payments, claims runoff, reconciliation, calculation of targets for what may be an abridged year, and how all that is settled. And then on a fee-for-service contract, the termination provision should create a drop-dead date, by which all claims must be submitted. And so those are issues that really need to be addressed in the contract. Now I'm moving on. I haven't gotten any questions or Q&A here, so assume that means there's none. So I'm moving on to formation of provider networks. This, I'll just say in advance, this portion of this presentation will be fairly high level. There's a lot here under federal and state antitrust laws. Too much to cover in a presentation like this, so I'll just give a glancing coverage of the fact that, when forming a provider network, antitrust is a key consideration. The sources on this are the the most important source on this is the 1996 joint issuance of the Department of Justice and the Federal Trade Commission, the Statements of Antitrust Enforcement Policy in Healthcare. And to distill that down to 2 points, and it's a very lengthy document, as it relates to provider networks is a network avoids a per se violation of antitrust laws, which means no analysis necessary. The agencies will treat it, simple existence of the network, as a violation of antitrust law if the network has financial or clinical integration. When you have financial or clinical integration among the providers, then the rule of reason applies, which is essentially a balancing test that will look, and the agencies will look at the balance of anti-competitive effects versus pro-competitive effects. So that naturally raises the question about what is clinical integration. The answer to that is a lengthy answer, and so I've tried to distill it here to some of the basics. It's defined in the Statements of Antitrust Enforcement I referenced on the previous slide, and in numerous FTC cases and guidance. Some of the key characteristics are clinical protocols and benchmarks, data monitoring and reporting, contractual model and accountability, technology, infrastructure, lack of market power. If you have a network that has too much market power, then you're probably going to have problems regardless of the amount of integration you have. I'm going to pause here because I actually did get a question. New to this WebEx, so I didn't notice it until just now. The question is, in Idaho, if a contract is terminated, is it the responsibility of the insurance company or payer to notify their members? If so, then can the member change networks at that time, or do they have to stay with the same insurance company? Well, it's a good question. It's a complex question, and it's going to depend on a lot of facts. But generally speaking, I think if the contract is with, we're talking about the contract with a single provider, such as one doctor. Typically, I don't think that will give rise to a right to terminate insurance contract and enroll in a different policy, or in a different policy from the same payer, or with a policy from a different payer. On the other hand, and again speaking broadly, if there's a large number of providers who are terminated such that the entire network covered by the plan ceases to meet network adequacy requirements, then all of the participants in the plan would be eligible for a special enrollment period. Again, good question, difficult to answer without particular facts, but that's the general rules of the road there. Termination of a single provider's contract would not give rise to a special enrollment period for an insured. Okay, moving on, going back to the topic of formation of provider networks and legal considerations. I talked about antitrust. In addition to antitrust, there is what I call the standard guardrails in healthcare transactions, which HIPAA, STARK, anti-kickback statute, civil monetary penalties law. These laws must always be considered, but I haven't given them much airplay here because most standard network models will fit within established safe harbors and exceptions. The analysis needs to be done each time to ensure that each particular proposed network will fit and that all of its operations are compliant, but it doesn't present a major barrier the way that antitrust law does, or major potential barrier. I'm going to turn to a new topic now, moving pretty fast. So you may get out of here before 1 o'clock. I hope that's not a problem for anyone who's planning to get a full hour of CLE credit or other continuing education credit. And if it is, just keep asking questions, and I'm sure we can keep this going till 1. The next topic here, and this is the new topic that I mentioned at the beginning of the presentation, is out-of-network plans. And I say it's an emerging issue. We've started to encounter it in our practice where TPAs and other consultants are advising self-funded employer group health plans to cancel network contracts. I think there's a typo on the slide there. That "and" it shouldn't belong there. What's happening is these outside benefit advisors. There's one in particular that, if you Googled it, what comes up with as their primary, seems to be their primary offering to their clients, which are employer group funded health plans, and the name is ELAP Services, are telling these plans to cancel their contracts with networks, to essentially be completely out of network with all providers, rather than what has typically been the prevailing practice with self-funded plans, where they engage a third-party administrator and rent networks from that third-party administrator, or will rent an independent network for their participants. The common scenario, or the way this plays out, is the group health plan will issue a card to the beneficiaries, has the name of a TPA that has a contracting network with providers in the area of the health plan. The health plan doesn't use the TPA, uses the TPA to process claims, but does not enter into a network agreement with the TPA. So in other words, it doesn't lease the TPA's network, but gets the TPA insignia on the card because the TPA is actually processing claims. The beneficiary will go in to a provider. The provider will accept the card and take an assignment of benefits from the beneficiary, which is all pretty much appears to be normal. But then what happens is the provider submits the claims to the plan for pre-authorized covered services, and the provider will either use billed charges, or if there had been a network contract in place in the past, the provider will charge the historical reimbursement rate. Behind the scenes, however, the group health plan has amended its ERISA plan document to limit the amount of provider reimbursements for services to something like, for example, 125% of Medicare rates. So the provider submits the bill under the assignment of benefits, gets back a notice from the health plan that the health plan has determined that it will pay 125% of Medicare, and the health plan delivers that payment. Typically, the next step is the provider will attempt to balance bill the patient for the difference between the charge for services and the amount the plan is reimbursed. You'd think that would be the plan's right, the provider's right, because it doesn't have a network contract, no negotiated discount, and the plan has just paid significantly less than what was the historically reimbursed amount for the same services. But what happens is the plan has a defense under ERISA. The provider is an assignee of benefits and therefore has accepted under ERISA the plan's claims procedures, and all disputes about charges or payments of benefits have to be disputed through the plan's claim procedures, which essentially means that the plan itself gets to decide whether the payment is appropriate and whether the benefits have been provided. And that's what happens. The plan will go through the motions of reviewing the services provided, provide a justification for why the amount paid to the provider was reasonable, and that's it. And they'll say that's you've exhausted your remedies. You've been paid all that you deserve as a assignee of benefits under the plan. What has happened in the past is some providers have sued and they lose. I've given a case citation here for a case that pretty much describes the facts that I've laid out here, and the result is that the federal court dismissed the case on summary judgment, saying that the plan had no right to payment beyond the amounts. Excuse me, the provider had no right to payment beyond the amounts specified in the plan. So how does a provider address this and defend against this issue? Well, there's really two approaches. The first is do not accept assignment of benefits from patients who are out of network. Well, actually, that's critical to any approach to dealing with the issue. Is providers have to be now in this environment where there's a number of employers who are doing this. Providers need to be really careful not to accept assignment of benefits from patients who are covered by employer group health plans and do not have a network agreement with the provider. It's worth the time to check because, as I've just walked through, the results are frustrating and surprising if you do accept the assignment of benefits. So with the starting point of do not accept the assignment of benefits, there are really two options. You can require the patient to pay, and then the patient can go seek reimbursement from their health plan, and in which case I suspect the patient will only receive the 125% of Medicare, but that will not be the problem of the provider anymore. Or the second option is to require the plan to agree in advance to a payment amount for those services, essentially a case-by-case contract. As patients come in, not ideal. Or to another alternative that is not on the slide, but it's actually what we've advised people is to tell the plan in advance we're going to cease accepting assignment of benefits, and unless you enter into a contract with us, reinstate our previous network agreement. Final point here on this topic, and actually final point in this presentation for this afternoon, is that although the case I cited earlier, the provider had been stung by this practice, lost the case, our analysis is that there may be legal remedies for providers who have been significantly stung by this. And examples are state or federal conspiracy and fraud laws, which it does not appear were alleged. It does not appear that the prior cases the providers were aware of the way that this was being promoted as a practice to numerous groups, numerous employer group health plans, and so they did not plead or allege conspiracy or fraud. There's also a problem, we believe, for any plan sponsor that does this has probably breached their fiduciary duties under ERISA to their participants. And as an assignee of benefits, the providers may be able to assert those breach of fiduciary duty claims. I'm pausing for a moment to see if anyone has any questions. Because that's all I had for today. So I'll give it another minute, but if there are no questions, then thank you for joining. The slides from today's presentation will be distributed. Excuse me, I was about to start rounding up. And I got a question. It looks like the question was on the same topic, the topic I was just discussing, and the question says, and I might classify this as more of a comment. We're finding that when the patient registers, they have a card that indicates XXX network, which benefits would then be in network. But when the EOB arrives, the plan says they are not following the XXX network rates that were presented on the patient's card. Yeah, I would agree with that. I think these plans are finding ways to validly display a network on the card. Maybe they're entering into a contract and then canceling it. I'm not exactly sure of how they're getting those networks on the card. One thing that I think providers could do is if they're members of that network, ensure that the network is requiring plans to cancel and reissue cards when they've canceled their network contracts, so that no one's getting fooled or hoodwinked by this practice. There may be some violations by the plans in use of the network trademark or other insignias that could be enforced against the plans that are doing this. I also think that, in my opinion, the fact that they're using the network insignias on the card is a very helpful fact if a provider actually wanted to pursue one of these plans for fraud, because that I think is a pretty good indicia of fraudulent intent. And I've got a few more comments on this issue, so I'll just read them aloud and address them. Not sure it is anything I can speak to, but one of the participants says that they're experiencing this issue and actually disputing it with the network mentioned on the member's card. I think that's a good approach. It's the first start, but without knowing much more about the particular facts, but from seeing this play out and having read about it a bit, my belief is that probably there's not going to be a remedy through the network, that the ERISA preemption and ERISA rules will be what applies in the situation. It's probably not much that can be gotten from the network, and not much recourse there. Okay, well, I think that handles the questions. I'm glad we got a little discussion going on the last point, these out-of-network plans. As I said, it's an emerging issue. I think that we'll see more of it before it goes away. Eventually, hopefully, people will catch on and providers will catch on and adopt practices that prevent them from being abused this way. But for now, it does seem to be prevalent. If there are no more questions, then I'll wrap up. I was starting to say that the slides will be sent out by email after the presentation, and they're available along with the recording of the webinar on Holland & Hart's Healthcare blog. Thank you all for coming, and this ends the presentation.